Okay. Well, I'd like to say a very warm welcome to everybody. I'm Peter Danchin, Associate Dean for Research and Faculty. It really is fantastic to see so many students, alumni, staff, and faculty all able to join us today for this session. This is the next in our installment of faculty webinar series, which we hope provide a way for the entire Maryland legal community to stay connected to the intellectual life and goings-on at the law school. Our next webinar, if you're interested and if you have your calendars handy, will be on Wednesday, the 4th of November, and will unsurprisingly focus on issues related to the upcoming election. So please put that one on your calendars. But today we have a really fantastic session, which of course is focused on the current Supreme Court term, which is now officially underway. And I'd like to hand over to my colleague, Professor Mark Graber, who will be moderating today's panel.
Well, thank you very much, Peter, and greetings to everyone from our bedrooms, basements, and kitchens to your bedrooms, basements, and kitchens. Now, lots of things have been said about Donald Trump, but one thing is very clear, that Donald Trump has been a boon to those of us who study constitutional law and think about it, with constitutional issues 200 years old and just recent coming up on almost a daily basis. And this year is unlikely to be an exception. We have a very heavy Supreme Court docket in terms of substance, in terms of caseload. The court has actually been contracting a bit. And Professor Natalie Ram, Richard Boldt, and Maxwell Stearns will talk about the doctrine. In addition to the cases they are talking about, religious freedom is at stake. One would expect the tax returns to come back, election law, COVID policy. All this is happening. And with the probable appointment of Amy Coney Barrett, we are likely to see a shift in the center of the court, perhaps dramatic. So the politics of the court is on display. And while we're going to start with the doctrine, I expect in the question and answer, we will have lots of time to talk about the politics. If you have a question, please use the chat function or the hands up function, and I'll try to recognize you. But we have three distinguished speakers today. The first, Professor Richard Boldt. He is the T. Carroll Brown Professor of Law and former Associate Dean with particular expertise in problem-solving courts and just a remarkable range of teaching between torts, criminal law, constitutional law, jurisprudence. He'll be talking about Jones versus Mississippi, a case which concerns when juveniles can be sentenced to life without parole. Our second speaker will be newly tenured Professor Natalie Ram, who is also a distinguished Greenwall faculty scholar in bioethics, who is clerked for Judge Guido Calabrese and Justice Stephen Breyer. Here, she's made a smashing debut teaching civil procedure and property. She'll be talking about Ford Motor Company versus Montana 8th Judicial District Court, a case which on the one hand concerns in personam jurisdiction, which seems of interest only to lawyers and turns out to be vital for fundamental rights and legal policy. Our final speaker will be Professor Maxwell Stearns, who is the Venerable Bathier and Howard Professor of Law. Professor Stearns is an internationally recognized expert on public choice, law and economics. Indeed, he has published the two leading textbooks on the subject. He'll be talking about California versus Texas, which is the latest episode in the struggles over the constitutionality, legality, and practice of the Affordable Care Act of 2010. And with no further ado, Professor Ram.
Hi, thanks, Professor Graber, and thanks to all of you for coming to join us for this event. You can hear me, right? Great. Okay, now I know that civil procedure generally, and personal jurisdiction in particular, is not typically the sort of stuff that shows up at a Supreme Court preview event, or that really gets the blood pumping. And civil procedure cases aren't often ones that break down on ideological lines. But the Ford case, which is being argued literally as I speak, is one that we should all be paying attention to because it may impact the logistical ability of everyday, ordinary Americans to sue manufacturers of defective goods that cause them injury. Personal jurisdiction describes the ability of a court to exercise power over a party to a lawsuit. If a court lacks personal jurisdiction over a defendant in a lawsuit, then the court has no power to bind the defendant to its judgment, and courts in other states don't have to give that judgment full faith and credit. The modern doctrine of personal jurisdiction, and here everyone can cast their minds back to their 1L year, personal jurisdiction doctrine in its modern form traces back to the 1945 case of International Shoe versus Washington. For present purposes, the important part of International Shoe is that in that case, the US Supreme Court explained that a non-resident defendant will typically only be subject to personal jurisdiction in a state for claims that arise out of or are related to or connected with the defendant's activities in that state, and only where the defendant has established minimum contacts with the state such that subjecting it to suit there does not offend traditional notions of fair play and substantial justice. Now, later cases have broken that language down into a three-part inquiry for what we now call specific personal jurisdiction. For a state to constitutionally exercise specific personal jurisdiction over a defendant, three things must be in place. First, the plaintiff's suit must, as I said, arise out of or be related to the defendant's contacts with the forum state. Forum state meaning the state in which the lawsuit is being brought. Second, the defendant's contacts with that state must meet that threshold of minimum contact. And third, it must be reasonable, that is, consistent with fair play and substantial justice, for the courts in the forum state to exercise jurisdiction over the defendant. In more recent cases, the Supreme Court has tightened up or raised the threshold for the standard of minimum contacts. And in a 2017 case, the court issued an opinion on the scope of that arise out of or relate to piece of the specific jurisdiction analysis. In that case, the court explained that plaintiffs couldn't sue a drug company in California for an allegedly dangerous drug where the plaintiffs didn't live in California, weren't prescribed the drug in California, didn't ingest the drug in California, and weren't injured in California. Importantly, though, the drug company in that case didn't challenge the ability of California residents to sue on those claims, nor had defendants in older cases disputed the ability of in-state plaintiffs to sue about allegedly defective products where the defendant sold the identical product in the forum state. All of that background brings us to the Ford cases, which are about products liability suits related to used vehicles that caused injury and death. There are actually two cases that are being argued together, so let me briefly describe them. The first is Ford versus Bandemer. Adam Bandemer, a resident of Minnesota, was riding in the passenger seat of a 1994 Ford Crown Victoria in Minnesota when the car crashed into a county snowplow and ended up in a ditch. When the Ford's airbag failed to deploy on impact, Bandemer suffered brain injury and disfigurement. Like Bandemer, the driver and the owner of the car were also Minnesota residents. The Crown Vic was registered in Minnesota and had twice been purchased secondhand in Minnesota. First in 2011 and then again in 2013 by the current owner. But it turned out that the car was first sold at a Ford dealership in the neighboring state of North Dakota, and it was manufactured at a Ford assembly plant in Ontario, Canada. Ford does, however, sell and advertise its cars in Minnesota. There are 80 licensed Ford dealerships in the state, which are authorized to sell both new and used vehicles. Indeed, Ford sold more than 2,000 1994 Crown Victoria cars in Minnesota. The second case is Ford versus the Montana 8th Judicial District Court. This suit involves a resident and a car accident in Montana. 23-year-old Markiah Gullett was a resident in Western Montana. In 2015, She was driving her Ford Explorer on the highway near her home when one of the tires suffered a catastrophic failure. The vehicle lost stability and rolled into a ditch, and Gullett was pronounced dead at the crash scene just outside of Alberton, Montana. Now, although Ford sells and services both new and used vehicles in the state, including Ford Explorers, at 36 licensed Ford dealerships in Montana, again, the particular Ford Explorer that Gullett was driving was assembled elsewhere. It was assembled in Louisville, Kentucky, and it was originally sold to an Oregonian at a Ford dealership in Spokane, Washington. In both suits, because the original sale of the vehicle in question took place outside the state in which the lawsuit was brought, Ford moved to dismiss the suit for lack of personal jurisdiction. Ford's argument is that the arise out of or relate to requirement for specific personal jurisdiction can't be met when the first sale of a particular item took place in a different state, even though the defendant regularly sells and markets the identical product in the forum state, and the plaintiff resides and was injured in that state. Ford's argument, in other words, amounts to saying that arise out of or relate to really means just arise out of. Ford argues that its contacts with the forum state must be the proximate cause of the plaintiff's suit, to take a phrase from tort law. Both the state Supreme Courts of Minnesota and Montana held that personal jurisdiction over Ford was just fine, that it was appropriate and constitutional in these cases. The US Supreme Court then granted certiorari to consider this question itself. And it's worth noting that the US Supreme Court reverses more often than it affirms the judgments that it reviews. And so the grant of certiorari in these cases bodes well for Ford. Now, we don't know how this case is going to be decided. We can't even read the tea leaves from the oral argument because, as I said, the oral argument is going on right now. But if the Supreme Court agrees with Ford, then I think that there are some consequences that may flow from such a decision that make this case extremely important for everyone. If the Supreme Court agrees with Ford, it might become very important to know the provenance of the products that you use. Because if you're injured by one of those products, your ability to sue in your home state would hinge not on whether the manufacturer sells the same product in your state, that is, whether you can find that product on an in-state store shelf, but whether the particular item that injured you was first sold in your state. One outgrowth of such a result is that if you and your neighbor are both injured by identical products, your neighbor might be able to sue the manufacturer in your home state if she bought that product new or not used somewhere in the state. But you might have to travel to another state to sue the same manufacturer for the same type of injury caused by the same mass-produced product if you happen to pick up your product used and it turns out that that particular item was first sold in another state. Now, cars have VIN numbers, and it's a reasonably routine matter to figure out where your vehicle was first sold. That's not to say that it would be easy for an injured plaintiff to travel to another state to bring a lawsuit, but at least the plaintiff might have a reasonable hope of being able to figure out where that first sale took place. But for most consumer goods, we don't keep those kinds of records. Most consumers don't keep receipts of everything they buy new in a store. And sorting out where an item you picked up at a yard sale was first sold would be nearly impossible. And yet, since it's the plaintiff's obligation to plead and prove that a court has personal jurisdiction over the defendant, it would be the plaintiff's obligation to prove the provenance of perhaps any consumer good if the defendant demanded it. Now, why would Ford make this argument? They're spending a lot of money to litigate this suit all the way to the Supreme Court. Why? After all, even under Ford's theory, Ford would be subject to suits about allegedly defective vehicles in Minnesota or Montana if the vehicles were first sold in those states, as thousands of them are. And even under Ford's theory, the plaintiffs here can sue Ford. They just have to do so in another state, maybe Michigan, where Ford is based, or in the state of first sale. So given that Ford isn't saying that the plaintiffs can't sue anywhere or can't sue at all, what does Ford stand to gain from arguing from this kind of rule? Well, I mean, it might be more convenient for Ford if more plaintiffs came to its home state, Michigan, to sue it, rather than requiring Ford to send its lawyers to other states to defend it. But perhaps Ford suspects that if plaintiffs have to travel far from home to bring a lawsuit, and especially if the bulk of the evidence and the witnesses are in the plaintiff's home state and would be required to travel as well, the practical effect is that fewer plaintiffs will have the means and the wherewithal to sue in the first place. In other words, keep an eye on this case. Personal jurisdiction might not seem like the stuff of major cases, but the doctrines of personal jurisdiction involve principles of substantive justice, and they can impact the practical ability of real people to have a real shot at a day in court. It's also worth noting that we may feel the loss of Justice Ginsburg acutely in these cases. Justice Ginsburg had a knack for and a passion for civil procedure issues. She also wrote that 2017 opinion that focused on the arise out of or related to boundary of specific personal jurisdiction. And I, for one, will really miss the opportunity to know what she thought that opinion meant. Thanks.
Thank you. Thank you is maybe that didn't fully get in. Now to Professor Boldt.
Thank you, Professor Graber. So the organizers of this event have selected an interesting subset of cases. We have personal jurisdiction, products liability, as you just heard, and in a moment, a towering case about the ACA. But my task is to talk about an Eighth Amendment case that's before the court this term, Jones versus Mississippi, and I will try to briefly walk through what's at stake. The case is, the question in the case is whether the Eighth Amendment requires a sentencing authority specifically to find that a juvenile is permanently incorrigible before it imposes a sentence of life without the possibility of parole. The case grows out of and concerns the scope of a constitutional rule announced by the court in 2012 in Miller versus Alabama, and then made retroactive in 2016 in Montgomery versus Louisiana. So beginning with the facts, Brett Jones, the petitioner, was sentenced to life without parole in 25 at the age of 15 after having been convicted of murder for killing his paternal grandfather. The death grew out of an altercation in the kitchen of the home where they shared, where they lived. Jones testified at trial that he was, quote, afraid and didn't know what else to do, and raised a self-defense defense, which did not prevail. Following the Supreme Court's opinion in Miller in 2012, the Supreme Court in Mississippi granted Jones a motion for post-conviction relief and vacated his mandatory life without parole sentence for a new sentencing hearing. The Mississippi Supreme Court directed the resentencing court to consider a set of juvenile characteristics and circumstances, sometimes referred to as the Miller factors, in deciding whether Jones should be sentenced to life with parole eligibility or without. The Miller factors include age at the time of the commission of the offense, family circumstances, circumstances surrounding the crime, whether the offender might have been charged and convicted of a lesser offense, if not for incompetencies associated with youth, and most importantly, perhaps, the possibility of rehabilitation. Now, Miller, the foundational case here, determined that sentencing a child to life without possibility of parole is excessive for all, quote, but the rare juvenile offender whose crime reflects irreparable corruption. Relying on Roper versus Simmons, in which the court had ruled that minors could not be executed pursuant to the Eighth Amendment, and Graham versus Florida, prohibiting life sentences for juveniles in non-homicide cases. The Miller court recognized that children differ from adults in their, quote, diminished culpability and greater prospects for reform, and that these distinctions diminish the penological justifications for imposing life without parole. Miller, in turn, was made retroactive in 2016 in Montgomery versus Louisiana, where the court's majority relied on Teague versus Lane, a federal habeas case, which set out a framework for the retroactive application of new constitutional rules. And essentially, what the Montgomery court, relying on Teague, explained was that new constitutional rules that are principally procedural in nature are not necessarily retroactively applicable, but that new watershed procedural rules, and for our purposes, more importantly, substantive rules of constitutional law must be retroactively applied. Substantive rules, constitutional rules, the court explained, forbid certain criminal punishments of certain classes of offenders. And therefore, those new substantive rules, because they define categorical guarantees that place certain criminal laws and certain punishments beyond the state's power, render convictions of those classes of individuals unlawful. The resentencing court in Brett Jones' matter heard evidence in February of 2015. The state rested on its trial evidence, put on no additional evidence. Jones put on 6 witnesses, mostly family members and a corrections officer. The witnesses testified that Jones had been subject to significant abuse as a child and had been diagnosed with a range of serious mental health conditions for which he was being treated. The corrections officer testified about Jones' rehabilitation. While incarcerated, he had been in prison for 10 years, that he had expressed remorse and regret, was a good kid who tried to do the right thing and got along with everybody. The officer also testified that Jones had sought out opportunities for work, was a good employee, had earned his GED, and hoped to take college courses. The resentencing court resentenced Jones to life without parole at the end of the hearing, and did not make a finding that he was permanently incorrigible, nor did it acknowledge that only permanently incorrigible juvenile homicide offenders may be sentenced to life without parole under Miller and Montgomery. The court saw its role instead merely as assessing aggravating and mitigating circumstances. Jones appealed his new sentence to the Mississippi Court of Appeals, which affirmed in a divided vote, as did the Mississippi Supreme Court. The sentencing judge, the Court of Appeals explained, must consider the Miller factors and must apply those factors in a non-arbitrary fashion, but need not make specific findings with respect to them. Interestingly, the court also made reference to an earlier Mississippi Court of Appeals decision in which the court derided the US Supreme Court's permanently incorrigible standard, calling it, quote, more like a theological concept than a rule of law to be applied by earthly judges. So the precise question then in Jones is whether a state collateral review process that includes a consideration of the Miller factors but does not result in a specific finding of incorrigibility or irreparable corruption is constitutionally adequate in separating those juveniles for whom life without parole is permissible from those for whom it would be disproportionate and thus a violation of the Eighth Amendment. The Montgomery majority decision was written notably by Justice Kennedy and was joined by Chief Justice Roberts and by Justices Ginsburg, Breyer, Sotomayor, and Kagan. Justices Scalia, Thomas, and Alito were in dissent. As you know, Justice Kennedy is no longer on the court, and Justice Ginsburg has passed away, and Justices Gorsuch and Kavanaugh have joined the court in the interim. Thus, pending action on the new appointment of Judge Barrett, the likely split on the court on the issue in this case appears to be 4-4. Back to you, Mark.
Okay, and now back to you, Max, or to you, Max. We're going to get better at handoffs as we use Zoom more.
Well, first off, thank you, Professor Graber, for your kind introduction, to Professors Boldt and Ram for joining the panel discussion, and to all of you who are attending this virtual event. I have to begin with the observation that California versus Texas is a singularly complex case. It involves an intricate statutory scheme, the Patient Protection and Affordable Care Act, also known as the ACA or Obamacare, as amended by the 2017 Tax Cuts and Jobs Act. The amendment followed the Supreme Court decision, National Federation of Independent Business, or NFIB v. Sebelius in 2012, and of course, the historic 2016 presidential election. I'll first lay a foundation for the issues before the Supreme Court, then I'll offer my reflections as to how these issues and the case as a whole should be resolved. I do not claim to predict how the case will be resolved, especially given the present uncertainty concerning the Supreme Court itself. So let's get started. In 2012, Congress enacted the ACA or Obamacare. The statute's over 900 pages long, and it possesses several intricate and interconnected features. These include the individual mandate, known also as the shared responsibility payment, a prohibition on insurance companies declining coverage or raising premiums for persons with pre-existing conditions, inducements to states significantly to expand the scope of Medicaid coverage, incentives to states to provide public health insurance exchanges, and more. My remarks are going to center on the constitutional issues. Professors Boldt and Ram in our healthcare program have greater expertise than I do on various aspects of the complex healthcare statute. The most controversial aspect of the ACA was the individual mandate. The mandate required uninsured individuals to acquire qualifying coverage or pay a modest penalty. Since 2016, the penalties have been assessed at $695 per adult, $347.50 per child, with a family maximum at the greater either of $2,085 or 2.5% of household income adjusted for inflation. In an article co-authored with Professor Leslie Henry from our faculty and also in the healthcare program, titled Commerce, Games, and the Individual Mandate, published in the Georgetown Law Journal, Professor Henry and I explained that the ACA sought to replace what economists describe as a separating equilibrium with a pooling equilibrium. Two separate pools of insureds, one with those at low risk, another with those at high risk, place the high-risk folks out of the market. Combining those pools lets the low-risk person help those at high risk afford their coverage. The article explains how the separating dynamic arises at a micro level within states and at a macro level across states, justifying, we argued, reliance on the Commerce Clause. The Supreme Court disagreed. The problem is that the young and healthy can demonstrate their lower risk to insurers, thereby securing attractive rates, whereas those with pre-existing conditions cannot do so, and so they confront prohibitively high rates. With rare exceptions, were individual states to mandate coverage for persons with pre-existing conditions, such uninsured individuals would flow into those states even as the insurance companies themselves would leave. This would replicate the separating equilibrium among states that states and insurance companies individually confront. The ACA sought to resolve this nationally, where such strategies are more costly. The ACA scheme included the individual mandate to encourage young and healthy persons, sometimes called the young invincibles, to enter the insurance pool as an inducement to compel insurance companies to cover persons with pre-existing conditions. Additional statutory features are designed to overcome, among other things, inevitable shortfalls in financing and coverage. The ACA faced constitutional challenges on the assumption that the statute implicated the Commerce Clause. This culminated in the Supreme Court case NFIB v. Sebelius in 2012. That landmark case proved a defining moment in Chief Justice Roberts' stewardship of the Supreme Court. Roberts wrote a controlling opinion, parts of which no one else on the court joined. In an opinion mistakenly labeled dissent, the court's conservative wing embraced Roberts' Commerce Clause analysis. Roberts ultimately determined that the ACA could not be sustained under the Commerce Clause based on his construction of the economic activities test. That relatively new test had been used to limit the scope of Congress's permissible Commerce Clause powers. Roberts determined that although Congress could regulate economic activity, it could not force people into commerce by compelling the purchase of health insurance. But to the chagrin of his conservative colleagues, Roberts wasn't done. He then determined that although Congress did not caption the individual mandate a tax, the mandate could nonetheless be sustained as a tax due to several characteristics: administration by the IRS, processing with tax forms, and the prospect of raising some revenue. Among Donald Trump's central presidential campaign promises was to repeal and replace Obamacare. The replacement remains something of a mystery, and despite Republican control of both houses of Congress during the first 2 years of the Trump administration, attempts at repeal had failed. Instead, in the 2017 Tax Cuts and Jobs Act, Congress eliminated the shared responsibility payments, setting it to zero. Uninsured persons face no penalty for failing to acquire a qualifying health insurance plan. The eliminated shared responsibility payment triggered a new round of litigation, culminating in a Texas federal district court decision striking down the individual mandate based on a determination that the provision was not severable from the rest of the act, bringing down with it the entire ACA scheme. A quick procedural note. Because the Department of Justice changed its position before the Fifth Circuit after the change in presidential administration, California and other states intervened to defend the Affordable Care Act. In addition, the Department of Justice sought to avoid having the entire scheme struck down, focusing instead only on those provisions that are claimed to harm the individual and state litigants. The Fifth Circuit, like the district court, divided Texas versus United States, as the case was then captioned, into three issues. Number one, do individuals for whom there's a nominal requirement to obtain insurance on threat of no penalty, and do states, subject to theoretical compliance obligations in assisting those who perceive such an obligation despite the absence of a sanction, have standing to challenge the constitutionality of the individual mandate on the ground that a zero tax cannot be sustained as a tax. Two, assuming standing, does the reduction of the individual responsibility payment to zero disallow sustaining that provision under the tax clause? And three, assuming affirmative answers to those two questions, can the shared responsibility payment be severed, or must the entire ACA fall? The Fifth Circuit affirmed the rulings on standing, and it also declared the zero payment an impermissible tax. The court then remanded for a more finely grained severability analysis. Given the ACA's complexity, the Fifth Circuit instructed the district court to give more attention to whether parts of the statute could be salvaged, even with the individual mandate struck down. The Supreme Court's grant of certiorari superseded that remand, and so here we are. I'll now offer some brief reflections on the merits. If you're in the legal fiction section of the library, now is the time to search out the section marked fantasy. Why? Although there are problems with the Fifth Circuit ruling on the other issues, let's consider what might prove to be the critical question: severability. Severability analysis focuses on whether the enacting Congress would have embraced the larger statute had it known a problematic provision would be struck down. There is some dispute as to whether the relevant Congress for the inquiry is 2017, which set the payment to zero, or 2010, which enacted the Affordable Care Act. The 2017 inquiry is straightforward. We know that Congress didn't intend to repeal the ACA because that's not what it did. It merely set the payment to zero. The courts below focus largely on the 2010 Congress, and in the ordinary course, that makes a lot of sense. Yet here it leads to a bizarre, indeed convoluted inquiry, and it goes like this. Would the 2010 Congress, which believed it was resting the individual mandate on the Commerce Clause, have thought that reducing the shared responsibility to payment to zero on the assumption it was not a regulation but a tax, assuming it knew that the tax it hadn't thought it was enacting would be rendered void if later set to zero, have thought that that tax, so inextricably connected to the overall scheme, that given all of this, it would not have passed the ACA to begin with. As a law professor of mine used to say, such hypotheticals are like asking, if you had a sister, would she like cheese? I do have a sister. In fact, she's in the virtual audience, and yes, she does. But more to the point, had the 2010 Congress known the individual mandate was unnecessary to encourage desired Obamacare enrollments, there's little doubt it would have enacted the ACA even absent the penalty. The goal, after all, was to get people insured by enlarging the pool, not to collect revenue, rendering the whole tax analysis misguided. Now standing. Standing is eminently nuanced. It involves conditions under which particular litigants can raise claims in federal court. In the 2013 Clapper versus Amnesty International case, Justice Alito, writing for a majority, elevated the injury prong of standing to demand it be certainly impending. In the 2016 Spokeo v. Robbins case, Justice Alito demanded a justiciable injury be concrete, not theoretical, or what might be labeled psychological. For example, feeling bound to buy insurance on threat of no penalty. I would never claim that recent standing cases are a paragon of consistency, but I will say that the Supreme Court's conservative wing might have made standing harder on themselves. Finally, the merits. Could Congress enact a tax later adjusted downward to zero while still being a tax? Yes. Taxation is a constant exercise in calibration, from too high to too low to just right. It's the Goldilocks rule. Do I think that this is what Congress was actually doing? Of course not. But remember, we are in the library's legal fantasy section. And for that, we have Chief Justice Roberts to thank all of you, and I welcome your comments.
Well, we're open for questions. Feel free to type a question, send it to me alone, send it to everyone, and I'll repeat it. Or I can even try to work the raise hand function. But I'll start with a moderator's prerogative to raise some of the more general questions. One of the things we sometimes teach in constitutional law is the Carolene Products footnote, which many people claim provided the foundation for liberal judicial review of the sort that inspired progressives to go to law school. And there are two readings of the Carolene Products footnote. One is the court was committed to a certain notion of democracy, so you protected the right to vote and the right of persons of color who were sort of fenced out from democracy. Another political science view was what the Carolene Products footnote did was transfer judicial services from, say, property holders who voted Republican to, in fact, constituencies of the Democratic Party. So as you look at the court, the three of you, do you see an underlying philosophy that explains conservative judicial activism? Or is in fact, say, originalism a means by which we transfer judicial services from more liberal groups to more conservative groups? So, thoughts on that one? Natalie is smiling. I'm hoping smiling is sort of just a thought.
Oh, I was going to say, I think Max probably has the most to contribute here, since he's a game theorist and a teacher of constitutional law, which I am not.
I'm going to pass it to Richard in the first instance.
I'll say a word.
Go ahead, Richard.
I'll say a word or two, but I want my colleagues to carry this load. I mean, I think footnote 4 in its origins and the elaboration of the ideas by justices on the left and the right is significantly about managing the institution's legitimacy. And I think fundamentally the question is, when is it not only appropriate, but sellable to the polity to take over fundamental decisions of policy, of politics, of values that are in conflict in society. And that question about legitimacy, about the assignment of decision-making authority between competing institutions is complex. And I think the justices on the court currently have different views about how much they care about managing the court's store or husbanding the court's limited amount of legitimacy. I suspect, I mean, the exchange just in the last day or two about the same-sex marriage case from several of the justices suggests that there are at least some members of the conservative wing of the court feeling more empowered, who are less concerned about managing that limited store of legitimacy. I suspect there are other justices arrayed across the court who think more about that and are likely to be regulated more by their judgments about what they can sell to the American public. I don't think that renders the court's decision-making political. I'm not, a straightforward, unvarnished legal realist. I think the court's doctrinal formulations are meant to manage those very issues. And I have no crystal ball about what a good or bad job they do as a group, especially if Judge Barrett is confirmed. It's clear that the then 6-person conservative majority will have a lot of discretion about how much of their stored up legitimacy they want to spend on the ACA case, on revisiting the rights of the LGBT community, on protecting manufacturers through the manipulation of personal jurisdiction and so forth. I mean, I think all of these data points are connected and they're related, not so much to a kind of gross transfer of interest from voters in one party to the other, but a broader agenda managed with some eye toward the overarching question of legitimacy. So that's my initial take, and it leads me to be extremely agnostic. Even in family conversations, I don't issue predictions. I know how conservative each of the justices is. I know where they come out on the merits. What I'm not confident about is their judgments about how much capital they're prepared to spend, how quickly they're prepared to spend that capital.
Yeah, so I'll just weigh in briefly, and I agree with the insights that both Professor Ram and Professor Boldt offered, and Professor Boldt offered one that I was inclined to offer up, which is these recent conversations with the public that Justices Thomas and Alito are having, for example, about same-sex marriage, which leads one to think that there's this sense of being emboldened to signal the kind of questions that the court would be open to, which ordinarily one doesn't necessarily think should be happening extrajudicially. And I think that there's that there's some concern about that. One of the things that I've sort of observed over the years is that we tend to have a capacity in the doctrines that matter the most to inform their foundations with competing premises that can benefit either the liberal or conservative wing of the court. And so when I hear things like the court is political, isn't political, I think it's the wrong question. I think the question is there enough play in the joints that in a situation in which a broadly worded doctrine or a broadly worded constitutional provision doesn't of its own or their own force answer a question before us? is there the possibility for a value-added premise that is plausible yet contestable? And how does the change in the court personnel affect which one is going to dominate? And this becomes particularly acute in a context in which activism can be described in competing ways. So you could argue, for example, that abandoning longstanding precedents is activist, or some conservatives would argue that departures from original meaning, whatever it takes to get there, is activist, and the whole world turns on that distinction. The whole world turns on whether we treat activism as disregarding precedent or whatever it takes to get to someone's conception of the contested notion of original understanding, which I have to refer back to my talk and say, very many of those original understanding claims are like, if you had a sister, would she like cheese? In the sense that the framers weren't thinking about those questions, whether they had sisters or not. So I guess I'll just leave it there.
Okay, a few things from the chat. First, the chat says Professor Boldt does a really good job when cold called. So we should all be pleased by that. We have a question for Professor Ram on special interest involvement in the Ford cases. Does she know anything about the amicus and what positions? And a series of questions for Professor Stearns asking if he would elaborate a little more on the Commerce Clause problems with the ACA and whether in fact Sebelius rendered moot whether a zero consequence mandate is a mandate. So let's start with Professor Ram, then move to Professor Stearns, and I'll be happy to repeat.
Great. So there are a variety of amicus briefs that have been filed in the Ford cases. I just pulled up the docket over on SCOTUS blog, and I see the Chamber of Commerce is supporting Ford. Pharma is also supporting Ford. That's not altogether surprising to see Pharma there in light of that 2017 drug liability case. That was a Bristol-Myers Squibb suit. They were the defendant there. And so Pharma certainly has an interest there. The Institute of International Bankers is there, as well as, by the way, the U.S. government. The U.S. government has weighed in on this case. That shouldn't surprise us, frankly, because in most cases, as I tell my civil procedure students, personal jurisdiction in federal court mirrors personal jurisdiction in the courts of general jurisdiction, the ordinary courts in the state in which the federal court sits. So if you want to bring a lawsuit in the federal district court in the District of Maryland, the personal jurisdiction that court can exercise will be whatever personal jurisdiction the state courts of Maryland could exercise. And so the United States has a stake in this question about how much personal jurisdiction state courts should get to exercise as well. And the US government has weighed in here, largely supporting Ford, and arguing that that Ford should prevail in this case. So that's pretty interesting. On the other side, supporting the plaintiffs in the suit, they prevailed below, so they're the respondents in the Supreme Court. And amicus briefs supporting them include all sorts of professors: civil procedure professors, civil procedure and fed courts professors, professors of jurisdiction. There are some amicus briefs from specific civil procedure professors as well. And it's not just the professors who support the plaintiffs in this suit. We also have Minnesota, Texas, and 37 other states and the District of Columbia. So you have the United States weighing in favor of Ford, and you have virtually, well, not virtually every state, but a very large proportion of US states saying, no, this is fine. And insofar as personal jurisdiction doctrine is about protecting the sovereignty of non-forum states, of the other states in which the lawsuit wasn't brought, which is, a contested notion, but something that comes up in a lot of the Supreme Court's personal jurisdiction cases, insofar as the court is worried about offending the sovereignty of other states where the lawsuit isn't happening. The fact that 39 states and the District of Columbia are weighing in to say, no, this is fine, totally fine with us, our sovereignty, not offended at all, might be persuasive. So I think those are kind of the the big amicus briefs.
Professor Stearns?
Yeah, so thank you. I will say, I think that it will make more sense for me to address the question of why this got struck down under the Commerce Clause first, and then talk about this notion of a zero impact mandate, which I think is a little bit misleading. So just doctrinally, here's what happened. The Supreme Court had issued two decisions in 1995 and in 2000, respectively. One is Lopez versus United States, and the other one is U.S. versus Morrison, involving the civil remedies provisions of the Violence Against Women Act. The first one was about the Gun-Free School Zones Act. And what those cases did was they worked a change in the formal doctrine in a category of Commerce Clause cases known as the substantial effects cases. And what it did was it created this new category that in order to satisfy, you had to demonstrate economic activity. Those two cases focused on the economic part. In other words, was regulating guns near schools, was regulating violence against women by imposing civil remedies, economic activity or non-economic activity. Now that's arguably, and I think persuasively arguably, a nonsensible distinction between economic and non-economic activity, but the majority of the court bought it. What Chief Justice Roberts and the conservatives did was they focused on the other side of the phrase and said that unless people are already in commerce, they're not engaged in activity, and that Congress doesn't have the means by which to coerce activity in commerce. You'll remember that I said in the last response that we have these broadly worded provisions in the Constitution susceptible of competing premises. This is exactly what it is in the context of the Commerce Clause. You can have a formalist premise where unless you articulate something that meets precisely the way the doctrine is framed, it's excluded, or you can recognize a more functional premise like Congress gets to solve structural coordination games, which is what Professor Henry and I argued. Obviously, the court chose the former, not the latter. So doctrinally, this case is not rested on the Commerce Clause. It's rested on the Tax Clause. And that's critically important going forward. The idea that there's I want to capture this question because I don't want to misstate it. The question is, if a zero tax would be a tax, did NFIB v. Sebelius run to moot the question whether a zero consequence mandate is a mandate? I don't think it's a zero consequence mandate. And this gets to the heart of the distinction between a tax and a penalty. This is a little bit oversimplified, but it basically works. Think of it this way. If it's a tax, the goal is to raise revenue, not distort underlying economic activities. If it's a penalty, the goal is to affect in a favorable way underlying economic activity, and one would be really, really happy never to collect a cent because the purpose of the penalty is to dissuade conduct. The anomaly here is if the ACA penalty were 100% effective, it wouldn't result in collecting a dime. But it would result in lots of people, to avoid paying that dime, enlisting in the insurance protocols consistent with the ACA scheme. And this is, again, I keep coming back to this idea that we're asking the question that makes no sense. We have to imagine Congress perceiving this as a tax when the whole purpose of this was not to collect money. The whole purpose of this was to get people enrolled. And if that were successful, no revenue would have actually been collected. I see another question piling on the ACA Commerce Clause argument.
If I could
Yep,
actually generalize that question to get everybody involved, which is Mr. Phillips has asked whether in fact COVID might cause the court to reconsider Sebelius. Could I phrase this broadly to disengage Professors Ram, Professor Boldt, and Professor Stern? What do you see so far as the impact of COVID on American constitutional law more broadly? As we have 5 minutes left, so this struck me as a good concluding. If each of you would take 2 minutes.
So for one thing, I think one of the silver linings maybe of COVID and the court is that, and this is not about doctrine, but it's about how we engage with the court. The court has moved to remote hearings of the cases, and now they are making them available in live streaming on C-SPAN and elsewhere, which means that I was listening to the Florida oral arguments live before I had to leave to come here. And that is something that the court has almost never done. It has almost never been available in real time to people not in the building. So I think that's actually, you know, a possible silver lining. On a less upbeat note, you know, the court's recent moves with respect to emergency alterations in election and voting procedures does not give me a lot of hope or confidence that the Supreme Court is going to take the increased risks of voting during a pandemic and give them a lot of weight in determining what kinds of special dispensation states should have or courts should have to make voting easier and more available to more people.
So quickly, again, I think it's very hard to predict medium term or even long term how a lot of these dynamics are going to play out. But my initial observation is building on Professor Stearns and Henry's article and Professor Stearns' explanation about what I refer to when I teach this stuff as sort of state incompetency, right? That from the very founding, one principle of our federalist system was that the enumerated authority of the federal government, the central government, should be interpreted relative to the capacity of individual states to manage problems, because often those problems manifest in markets that cross state lines. And so when you think about the current public health crisis we're in, I would say, this is a descriptive claim, you know, states and localities have done a better job than the federal government so far in making adjustments, enacting public health policies and responding helpfully. The federal government has been largely unhelpful. There was the stimulus package, which, you know, one can quarrel with in terms of how those resources were allocated. But there's been, as we all know, less relative leadership from the federal government with respect to public health measures. So you could draw from that the lesson that you know, we need to return to a more robust federalist system in which states are laboratories and regulatory authority is returned to the states, which has long been really more a conservative judicial position. Or you could draw the competing lesson, which is that we're in the mess we're in because the states, while they've done the best they can, fundamentally are overmatched, and that effective interventions needed to come from the federal government. That this is a quintessential example of the kind of set of interlocking problems that necessarily require policy making, resource allocation, and the like at the national level. And if that's the lesson you draw from this, then it seems to me the very set of premises that underlies Chief Justice Roberts' position in Sebelius are placed in jeopardy. Not that the Chief Justice and the conservatives are going to rethink that in the short term, but I think the logic of what we've experienced over the last 6 months is that there are some things that the states, although toiling heroically, simply cannot manage. And that therefore it may ultimately, longer term, lead to an understanding of the Commerce Clause as embracing a broader array of federal government authority. That's my rosy possible longer term outcome, although I'm not prepared to put any money down on it.
Okay,
So
we're
let us
running
stop.
out of time, but Professor Stearns,
All right, let me just stop for a moment.
We can't get to all the questions, but Professor Stearns, you get the final 2 minutes.
Great. So I'll just try to keep this really brief. I just want to say there is a real politic thing we just have to think about here, which is that if the court struck down the entirety of the ACA, we're talking about huge numbers of people who may have contracted COVID no longer having insurance. I think one of the things that's going to be a driver here is who is the median on this court? We don't know. And I do think that Chief Justice Roberts, my gut tells me, is that he would try to find a way to salvage this thing. He is going to figure out a way to do a dance that salvages either the zero tax or rethinks the Commerce Clause. I don't know, but that strikes me as at least plausible. And I'll just say on the alternative pair of lessons that Professor Boldt offered, I have to lean the latter. I think that there are structural impediments to having states and localities resolve these kinds of problems, even as the problems politically that we confront today have not used federal powers in a way that could have been used in a benign manner to ameliorate some of these challenges. I don't infer that the lesson from all of this is a reversion to states as labs in areas where there actually is a genuine market structure problem calling for a national solution. I think that would be a mistaken and tragic lesson. The hope is that we have better leadership that can actually deploy the tools available effectively to avoid some of the tragedies that we're witnessing. So thank you. I hope I stayed under your 2 minutes, Professor.
Well, thank all of you. Thanks especially to Professors Ram, Stearns, and Boldt for really wonderful presentations. Thank you for joining us, and we hope all of you and your friends are back in 4 weeks, where we'll have 3 distinguished members of our faculty talk about the implications of the national election for American law. Thank you very much. Have a good day.